Well, good afternoon. I'm James, and I'd like to welcome you to this session entitled War Crimes from the 1945 San Francisco UN Conference to today. This conference is sponsored by no fewer than 4 societies: the Northern District of California United States Historical Society for the Northern District of California, the Northern District Historical, the Ninth Judicial Circuit Historical Society, the San Francisco Historical Society, and the San Francisco chapter of the Federal Bar Association. And in the next 90 minutes, we're going to connect decisions that were made right here in San Francisco at the end of the Second World War to all the way to the present and the present crisis raging in Eastern Europe. What are war crimes, and how can offenders at all levels and in all locations be identified and brought to justice? This is a hybrid program with people here in the beautiful Ninth Circuit Courthouse in San Francisco, and about 150 or more visiting on Zoom from around the country and globe and all the ships at sea. For those of you present here in person, please turn your cell phones off. For those of you on Zoom, in the Q&A or chat function, you can put in some questions. We'll leave time for Q&A at the end. We'll take questions from the live audience here first, and then some from on the screen. And for people who want continuing legal education credit, this program's been certified by my law firm, Pillsbury, Winthrop, Shaw, Pittman, for 1.5 hours of general credit. And I'll come back at the end to give the secret code for those who want to get that credit and fill it in on their forms. And I should say our invitations to everyone said that for those who are seeking CLE credit, the program materials are available at a link. Well, guess what? Even if you're not going for CLE credit, those materials are still available at that link. And you'll see the identity of our program participants and attachments from the Yalta Conference, the United Nations Charter, and the Statute of Rome, which defines war crimes for the modern era. So that's a link that should be available through Eventbrite or through contacting us for everyone, not just the CLE folks. So you'll note that the co-sponsors have some things in common. They're historical societies or legal societies, and their mission is focused on the Western United States and San Francisco in particular. Board members of each of these historical society wanted this conference not so much to teach, but as to learn about war crimes, other types of atrocity crimes, as we'll hear. I was one of those people. I was one of the ones who said we should learn about this, but my immediate question was, what business does a San Francisco Historical Society have talking about Ukraine? To be sure, any citizen anywhere has an interest in justice everywhere, but what is it specific about history and about San Francisco that leads us to facilitate this conversation? And so I resolved to answer my own question and proceeded to learn about those 60-odd days from late April till late June in 1945, when the world once again rushed in to San Francisco, when the San Francisco Conference on International Organization was held just across the way on Van Ness Avenue. There is a general overview book, Act of Creation, by Stephen Schlesinger, which I commend to you. And I found a great deal of other primary and secondary literature on the subject, and I'm in this keynote going to highlight some of the relevance of San Francisco to 2023 and the issues that we face today. So working backwards, the principal output of San Francisco was the Charter, the United Nations Charter, which has only been amended 3 times in the last 79 years. And one major factor in the effort to prevent and punish war crimes in those 79 years has been the veto right of the 5 permanent members of the Security Council. They have, and these of course are from the United States, the United Kingdom, France, originally the Union of Soviet Socialist Republics, now somewhat controversially held by the Russian Federation, and originally the Republic of China, Chiang Kai-shek's Republic of China, now held by the People's Republic of China. And in those 79 years, or even more recently, the veto or the threat of the veto has been used to prevent collective action in the former Yugoslavia, Darfur, Rwanda, Sri Lanka, Yemen, Syria, Myanmar, and now in Ukraine, with Russian Federation casting a veto just last year. Scholar Jennifer Trahan points to the lack of responsiveness to the commission of atrocity crimes, which we'll learn is the umbrella term that includes war crimes as well as other offenses. And she notes that much of the time that lack of response by the international community can be traced either to the veto or to the threat of its use. But the final charter that was enacted here at the Opera House was passed unanimously. And so I first asked the question, why 5? Why are there vetoes at all? Why are there 5, and why these countries? Also, it was my first chance to actually, as an adult, read the relevant parts of the charter and find that there are exceptions. There are things that the veto does not apply to. Why those exceptions and not others? These are things that were contingent outcomes of San Francisco, things that might have come out differently. So to understand why there are vetoes, you have to go back from the Veterans Hall here in San Francisco to the Hall of Mirrors at the Palace of Versailles, where the treaty ceasing hostilities with Germany was negotiated or imposed at the end of the First World War. And that, of course, produced a League of Nations, which had a charter that provided with limited exceptions that every country had a veto. There were 15 countries on the what was the small council and 58 countries eventually in the General Assembly. And the rule was that any action to be taken at those bodies with limited exceptions required the agreement of everyone present. And that veto applied even in situations where it was a vote that involved your own country, what in other systems might call out for a duty to abstain. And this abstention concept is one we'll come back to. The League had a lot of shortcomings, others of which led the Republican-led Senate to have the United States not ratify Woodrow Wilson's own treaty. But one of the big problems was this universal veto, so that when Manchuria was invaded in 1931 and China sought even the preliminary remedy of launching an investigation, Japan simply vetoed the resolution and eventually exited the League. Germany, Italy, USSR similarly deflected actions of this type. Now, it is true the League of Nations did resolve a border dispute between Colombia and Peru and stabilized Albania. But the relative size of the hits and misses bears out the comment of Benito Mussolini that the League of Nations is well and good when sparrows shout, but no good at all when eagles fall out. And the same can be said of many international organizations, not least of which is the UN. So by the time of Munich and the start of World War II, the League of Nations was a spent force, and people remembered all those vetoes. So when the leaders of the 3 major Allied powers, Roosevelt, Churchill, Stalin, met in various conferences during the Second World War, they envisioned a new international organization. And FDR's concept was that 4 policemen, those countries plus Chiang Kai-shek's China, would act to deter any aggressor nation. And therefore they should, in FDR's words, stick together. And therefore the staff developed charters for the new organization that would require all of those parties to act unanimously. And as the war in Europe drew to a close, the fateful conference at Yalta resulted in the invitation for the world to come to San Francisco because they accurately predicted that the war would still be raging in the Pacific Theater in the spring of 1945, and resolved to have the United Nations chartered there. A dispute arose before California on this abstention concept. The staffers for the Americans, the British, and Chinese said that, gee, if your country is involved in a vote, you should sit that one out. But Joseph Stalin opposed that fiercely, asserted a unity concept that even on matters affecting your own country, you should have this veto. And that's the basis for the common understanding people have, is that the entire veto was forced upon the world by Stalin. And that's an overstatement. First, nobody was disagreeing with the concept of a veto as to other countries. So in the situations of Darfur or Rwanda, even the American, British, Chinese concept would have allowed a veto to apply there. The only place where there was a disagreement was this exact situation where a resolution was adopted or called for with respect to Russia and Ukraine. And second, notice that I said the staffers advocated for abstention. By the time the politicians got the concept in their mind and said, well, gee, what would happen if the United States and Mexico got in a dispute? Would the US really want to be sidelined when that question was being debated? They started to see the advantages of Stalin's position. As James Reston of the New York Times wrote, The Soviet Union and the American Senate both opposed veto weakening, and no group of nations can oppose such a coalition. So communists in Moscow and hawks in Washington, D.C. could move mountains and work wonders when they were both of the same mindset. You'll notice I've only mentioned 4 powers so far. How do we get to 5? France, recently liberated, was wobbling between being the leader of the independent countries and being the junior partner of the bigger countries. And it took some time for the Americans and the British to play on the French sense of dignity and their desire to control their colonial empire before they made 5. By the time you got to San Francisco, there were other changes in mind. For a time trying to placate South America, it was proposed that Brazil would join. And so 6 vetoes would have been possible. Smaller countries, especially led by Australia, called for 10 vetoes, or perhaps alternatively, the requirement that 3 vetoes be cast in order to block a motion, in each case craftily limiting the power of any one country. But the 5 major powers held firm, and so when you look in Article 27 of the UN Charter, you'll see that a vote requires concurrence of the permanent members, the 5 permanent members. Now, what about those exceptions, which I didn't realize even existed? So there's an exception for peaceful settlements of disputes. If your country has entered into a ceasefire, you have to sit out votes to enforce that ceasefire. Once you've agreed to a resolution of a dispute, your veto doesn't apply. But the other one that came up in San Francisco was in June 1, and remember this is from April 25 to June 25, so relatively late in the conference. The Soviet Union suddenly said, oh, by the way, that veto, it also applies even to discussion of an issue at the UN. So the US would not be a place where you could discuss uncomfortable subjects. That battle required resolution of something completely different, namely Poland, of all things. As the Red Army swept into Poland, they instituted a communist government in the city of Lublin, as opposed to the government in exile that had been in London ever since 1939. And Stalin made only vague promises to hold fair elections in the future, and fatefully the West decided not to ask for anything more specific. And so on June 6, 1945, the 1-year anniversary of D-Day, once Stalin knew that he had Poland in his pocket, he conceded on this discussion right issue. And so you won't see any constraint in the UN Charter. That constraint, that absence of that constraint is significant because it enabled the UN to serve as a function for discussion and ultimately persuasion on the great post-war conventions on international humanitarian law, all of which had some amount of consensus at the United Nations. The 1948 Genocide Convention, the 1948 Universal Declaration of Human Rights, the 4 Geneva Conventions of 1949 and later protocols, and most recently, the 1998 Statute of Rome, which established the International Criminal Court. So in other words, no one, not the Soviets or Russians, not the Americans, no one could turn off the microphones of the World's Forum. And we'll hear more about those humanitarian treaties today. So blame San Francisco, if you will, for the vetoes that have prevented enforcement and prevention of war crimes. But credit San Francisco for enforcing the discussion right that led to these post-war conventions, which are being used today. Both sides of that compromise deserve to be remembered. So finally, I want to mention 3 other things that happened in San Francisco relevant to today's topics. First, it was in San Francisco that the Ukrainian Soviet Socialist Republic was admitted as a full member of the General Assembly. And Mr. Cocktail himself, Vyacheslav Molotov, gave an impassioned speech saying that this independent country, it and what is now Belarus, deserved membership in the League of this new League of Nations because they had borne the brunt of the Nazi invasion. And so they were fully independent countries entitled to presence in the UN. And it's very painful to read these speeches today in view of Moscow's current position that Ukraine is not a country at all. Secondly, the conference did not live up to the UN Charter's reference to the equal rights of large and small nations alike. Small countries bitterly opposed the veto, particularly as to matters that didn't involve the military. Much of Asia and Africa in 1945 was held in the form of colonies. And if you look at the Yalta invitations in the program materials, you'll see the rather cynical deal that Axis colonies were given the pathway to trusteeship and freedom, while Allied colonies would remain Allied colonies until the Europeans and Americans decided to relinquish them. There was very limited voice for women, for minorities, for citizens of less developed countries in San Francisco. And that's an impoverished view of international justice, one that's taken many years and many treaties to overcome. It's an uncomfortable truth, and in view of today's controversy about school curricula, if history makes you uncomfortable, then history's doing its job. And then third, it was in San Francisco, the brand new president of the United States, Harry Truman, announced to the gathered delegates that it would be a Supreme Court justice who would be the prosecutor for the Nuremberg trials that were going to be convening that winter in 1945. And to have someone of the stature and eloquence of Robert Jackson as prosecutor helped to respond to the charges of retroactive crimes and victor's justice, although those concepts still resonate and are relevant today. Nuremberg Courtroom 600 served as a model for ad hoc tribunals in lieu of formal courts for Japan, the former Yugoslavia, for Rwanda, and may still be a model for the present crisis. So I would argue those 60 days in San Francisco were responsible to some extent for, number one, the vetoes that have prevented collective action on atrocities. Number two, the discussion right that gave rise to these great post-war humanitarian treaties. Third, the limited voice of less franchised citizenry on humanitarian matters. And fourth, the elevated status of these ad hoc tribunals as an alternative to formal courts. So I conclude that there's plenty of reason for San Francisco historical societies to be facilitating this conversation today. So with that, I'm going to turn to our panel and to our moderator for the session, who will interview and interrogate and introduce our scholarly and diplomatic panel. My good friend Jeff Bleich is a recovering diplomat and scholar himself. If I turn just to his public law part of his resume, he holds a certificate in public and private international law from the Hague Academy of International Law and has taught international human law at UC Berkeley Law. He was legal assistant at the Iran United States Claims Tribunal at The Hague and special rapporteur for the Permanent Court of Arbitration, and also an advisor to the War Crimes Tribunal for the former Yugoslavia, as I mentioned. He was also chair of the Fulbright Scholarship Board, and most notably, he was ambassador of the United States to Australia during the Obama administration. So I'll turn the microphone over to Jeff, and I'm grateful to you for your time and kind attention. Thanks very much.
Well, thank you, Rob. Really appreciate your setting the table so elegantly and whetting everyone's appetite for the rich feast of information that's going to come from our two extraordinary and distinguished panelists, Professor Laurel Fletcher and Professor Saira Mohamed. As Rob mentioned, the reason that we convened for this panel is because whenever there's a significant human rights issue in the world, San Franciscans want to participate. And we wanted to help non-experts, in particular in the legal community, answer some of the questions about what legal recourse we have for all the alleged atrocities committed by Russian forces following its invasion of Ukraine. Now, while the actions have been broadly condemned internationally, even very sophisticated lawyers are often not sure what can be done about it. What actually constitutes a war crime, and how does it differ from crime against humanity and other international criminal offenses? Or most of us don't know exactly where or how those crimes are charged and adjudicated, and how any sentences are actually enforced, and also the specific information and evidence that's required as a practical matter to hold war criminals and human rights abusers to account. Fortunately, though, we've got some experts. Now, we were going to have three experts, and unfortunately, David Cohn, who leads the Center on International Human Rights and International Justice at Stanford University, was going to join us, but he's, this is what happens when you leave Berkeley and go to Stanford. He caught a bug from his students and so was unable to attend. Just we've got an all Berkeley crowd up here, sorry. So first we're going to turn to Professor Fletcher, who's a clinical professor of law and co-director of the International Human Rights Law Clinic at UC Berkeley. Laurel's has worked to address and to publicize human rights issues in many nations, including Sri Lanka, Myanmar, Burundi, Guatemala, India, Chile, probably, you know, it's a very sad list of countries. There are so many nations that have had significant human rights abuses, and she's going to help provide practical insights into how crimes against humanity and humanitarian crimes are actually handled. So based on her work with the Human Rights Clinic, she's going to bring a particular focus from the perspective of victims and how in practice the system does or does not work. She'll cover some of the key questions that arise in these matters, including whether a matter should be handled through an ad hoc tribunal or through the ICC, how proceedings in matters you know, such as the former, there was an international tribunal for the former Yugoslavia, a similar one for Rwanda, and other current horrors have shaped the law and shaped various processes. And then we're going to turn to Professor Mohamed, who's also a professor of law at UC Berkeley and a former senior advisor to the special envoy at the U.S. For the U.S. and Sudan, to unpack some of the technical aspects of first, what is the difference between a war crime and crime against humanity, and help us better understand the international regimes in play and specific legal definitions and nomenclature, and cover the question of the day, which will be, how war crimes that have occurred in Ukraine are likely to be dealt with. Then I'm going to ask some questions for both of them and open it up to all of you for questions, and time permitting, the millions of viewers on ships that Rob was describing all around the world who are watching us remotely. So before we begin, I was going to offer a little bit of context about war crimes and the situation in Ukraine, just to set the table a little further. So without preempting your comments, war crimes are kind of a bit fuzzy term. There's no single code that establishes what constitutes a war crime. And in addition, when we speak of war crimes, often what we mean are things that go beyond the specific laws of war, to include crimes against humanity, acts of genocide, and other things that may occur outside of or adjacent to an actual war. So one helpful way to distinguish war crimes from crimes against humanity is that war crimes may involve an isolated act against either civilians or combatants, whereas crimes against humanity are part of a widespread or systematic attack directed against civilian populations. While the panelists are going to help us untangle the various strands here, it may be helpful to identify some of the types of things that may qualify as criminal so that we consider their relevance to the events we've heard about in Ukraine. Among other things, international criminal laws forbid deliberate killing of civilians, deliberate attacks on civilian targets, including hospitals, homes, schools, churches, theaters. The use of banned weapons, such as biological weapons or cluster munitions in densely populated civilian areas, the abuse or killing of captured persons, the torture of soldiers or civilians involving willfully causing great suffering, hostage taking, acts of sexual violence and other serious injury to body or health, and of course, extermination. Now, there are allegations of all of these things in the Russo-Ukraine war. A bit of background on that war. The war itself formally began in 2014. Back then, the puppet government of then President Viktor Yanukovych had attempted to reverse years of Ukraine embracing the West, and instead he wanted to re-embrace the Russia under Vladimir Putin. This led to street protests in 2013 against Yanukovych that grew into a popular uprising known as the Revolution of Dignity. Those clashes grew violent. Yanukovych fled to Russia while Russia continued supplied pro-Yanukovych forces and separatists in the Donbas region. This culminated in Russian troops and Russia-backed paramilitaries annexing Crimea, which you may recall, and seizing 2 provinces in Ukraine's Donbas region. Skirmishes and near constant Russian cyber assaults have continued ever since. But international attention largely drifted away from Ukraine and the ongoing war there. And that changed briefly during the Trump administration when evidence emerged that President Trump seemed to hold military support for Ukraine hostage in exchange for demands that Ukraine leaders supply him with dirt on his potential political rival, Joe Biden. But that's for another panel. Instead, following Joe Biden's election in 2021, Russia began a year-long military buildup before launching a massive invasion of Ukraine on February 24th, 2022. The president of Russia, Vladimir Putin, declared that he did this to protect the people of Donbas from humiliation and genocide, which required complete demilitarization and denazification of Ukraine. In other words, he was planning to eliminate all pro-Ukraine military forces and the Ukrainian government. Russia deployed overwhelming force and brutality and expected that all this would produce a swift victory. But instead, they encountered extraordinary resistance from the people of Ukraine, ordinary citizens, as well as Ukrainian forces who managed to stymie their advance, disrupt their supply lines, and inflict heavy casualties on Russian forces. Russia responded to that campaign in a way that involved brutality and alleged atrocities. These include documented missile strikes on civilian targets, including houses, hospitals, schools, kindergartens, churches, and a theater, which was serving as a refuge for young children. The U.S. currently estimates that 40,000 Ukrainian civilians have been killed since the invasion began. Invading Russian soldiers have been accused of horrifying acts against civilians. After Russia's withdrawal from the town of Bucha, which is north of Kyiv, Ukrainian prosecutors and international human rights groups documented evidence of 400 civilians being executed, including 50 who were allegedly shot and killed en masse by Russian troops. Multiple cases of torture, mutilation, rape, and looting. More than 1,200 bodies of civilians were recovered in that region, including several whose wounds confirmed that they were summarily executed. In addition, approximately 5,600 Ukrainian soldiers have been captured, and the humanitarian research labs identified 21 different what they call filtration camps in and around Russian-controlled regions that are used for housing Ukrainian citizens, POWs, and other personnel. They're used as interrogation centers, as prisons, and at least in one case as a graveyard. There are reports of torture, insufficient sanitation, food, water, cramped conditions, and many other violations of the Geneva Conventions. The prosecutor for the International Criminal Court has since opened a full investigation into past and present allegations of war crimes, crimes against humanity, or genocide committed in Ukraine. At least 2 other independent international agencies are also investigating these violations. And by late October, the Ukrainian prosecutor's office had documented 39,347 alleged Russian war crimes. People who are experiencing these nightmarish horrors are people just like us. Folks who less than a year ago today were going about their daily lives, running their businesses, going to movies, playing with their families, living peaceful and productive lives. And the people who are perpetrating these acts know full well what they're doing. Their actions are deliberate, they've been systematic, and they are ongoing. And the question for the panel is, what can we do about it? And so with that, I'll turn to Laurel Fletcher.
Thank you. It's a pleasure to be here this evening, and I'd like to thank the organizers for the opportunity to be here and to join this conversation with you. This evening, I want to talk about international criminal accountability, and in particular, what this has meant for victims. So I'm going to first comment on the trend that we saw at Nuremberg from post-conflict justice to what we have today, which is justice during conflict. Second, I want to talk about how victims have become important to the legitimacy of international criminal justice, but also frustrated by what it can deliver. And finally, I want to offer some observations on the perennial question of what do victims want? And spoiler alert, it's reparations, not generally criminal justice. So I want to situate our discussion of a victim's perspective on international justice in historical context to highlight that victim participation in justice proceedings is a relatively recent development. In the wake of their victory, the Allies created the first international mechanisms to prosecute war crimes committed during World War II. And justice in that context was necessarily retrospective, a retrospective exercise in which criminal accountability for war atrocities was but one component of post-war reconstruction. Reparations, demilitarization, and a new constitution were other measures imposed on a vanquished Germany that were thought by the Allies to be necessary components to rebuilding Europe and a democratic future. Now, the Cold War put a hold on international cooperation needed to create justice mechanisms for conflict-related violence after Nuremberg and Tokyo. Until, that is, after the fall of the Berlin Wall in 1989, then, and only then, it became possible to foster the international consensus at the UN Security Council needed to create the ad hoc criminal tribunals for the former Yugoslavia and Rwanda. I want to thank Ron for highlighting the use of the veto and why that stymied efforts until the geopolitical realignment that took place in the fall of, in the dissolution of the Soviet Union. So in Rwanda, the genocide was brutal, but it was short-lived. And the Rwandan tribunal began to operate after that conflict concluded. However, in the case of the former Yugoslavia, the tribunal was the first international criminal mechanism to begin operations during armed conflict. And while there were practical challenges to operating the tribunal in this context, the possibility of criminal accountability for atrocities that were taking place in real time changed the public debate and the politics of international justice. And victims were a driver, a main driver, I argue, of this change. Why? Because the demand for accountability by many victims and their families provided critical moral legitimacy to international criminal justice. Proponents were able to argue that calls for international prosecutions were grounded on the fact that trials serve victims and their communities by punishing wrongdoers and so putting an end to cycles of communal violence. Trials facilitated reconciliation and strengthened rule of law and rule of law values that were thought as necessary preconditions to peace and stability. So these assertions supported the establishment of the ad hoc tribunals in the 1990s and 2000s. And these arguments also generated momentum and helped create the Permanent International Criminal Court. Not only were victims in general thought to want justice, advocates of prosecutions argued that victims who participated in trials received additional benefits. They would become empowered to narrate the truth of their experience of violence in a judicial forum to receive acknowledgement of the international community of the truth of their experience, which had legal consequences such as condemnation. And it also facilitated their ability to move ahead with their lives, in that sense, to put the past behind them. And that acknowledgement by a court of the victimization that they had endured would promote acceptance of victims in their communities. Now, the ICC has opened several investigations during active conflict, including in Darfur, 2005, Libya in 2011, Mali, 2013, and of course, most recently in Ukraine in 2022. The voices of victims in relation to justice generally appear in press accounts in which they describe the attacks to which they have been subjected, describe their suffering, often in excruciating, somewhat pornographic detail, and their desires that the perpetrators be brought to justice. Second trend I want to talk about then is the rise against this backdrop, perhaps ironically, the rise and then the retreat of victims' participation, even as they become more visible in the discourse around international justice. As former ICC prosecutor Luis Moreno Ocampo has forcefully asserted, the ICC has legalized international conflict resolution. It has also politicized it. This has meant, as the anthropologist Kamari Clark has argued, that victims do not participate in this international legal order as political citizens, but as depoliticized actors whose concerns are only made visible by the intervention of the international community. Like the Nuremberg Tribunal, the ad hoc criminal tribunals did not provide for direct victim participation. In response to criticism from victims advocates, the ICC was designed. Provisions were written into the Rome Statute that gave victims limited rights. For example, victims can influence investigations at the front end of proceedings by filing documents with the prosecutor that include evidence to substantiate the basis for the prosecutor to open an investigation. So on the front end, victims influence what justice looks like. And then victims that are recognized by the court are entitled to reparations on the back end at the conclusion of proceedings. Now, supporters intended these reforms to engender greater victim satisfaction with international justice. Yet, as several scholars have noted, the response by the court to victims has been one of ambivalence. And in fact, the ICC has interpreted fairly narrowly the eligibility requirements for who the court will recognize as a victim with legal rights. Partly, this is driven by the practicalities of administering justice. In any particular conflict, there may be thousands of potential victims, right? We just heard Jeff recount some very alarming statistics, over 40,000 civilian casualties and 40,000 alleged Russian war crimes. That's a lot of victims. How can one court actually accommodate that? So part of the work of any court, including international courts of criminal accountability, is to distill this complexity of mass atrocities to a scale by which individual wrongdoers are held accountable. Yet along the way, the court has trimmed, some might say gratuitously, the ability of victims to shape justice. Thus, the treatment of victims relative to their desires for what the court can accomplish has raised questions about the extent to which international courts are really ever able to successfully engage those affected by violence. But victims may also be beneficiaries of reparation programs, but they have lost their identity as political citizens who exercise agency regarding what justice might look like, as they would do if they were if justice took place in a national context. For example, the international legal order subordinates victims as citizens in determining whether criminal prosecution or other justice processes are preferable. In other words, there's no standing international mechanism to repair communities that are torn apart by violence. In other words, we don't have a mass reparation scheme that is permanently funded by the United Nations to which victims can make claims. Right? The Iran-U.S. Claims Tribunal is a prime example, was one that was specific to a particular time and context and where there was revenue to actually fund it. So this configuration of victims has particular resonance for the ICC in Africa, where prosecutions play out in a post-colonial context and are in tension with the political project of empowering Africans to take charge and to determine for themselves what justice looks like. The same, I will say, we were going to see, if not now, in the future in Ukraine, as Ukrainian victims may actually have a different understanding and different vision of what justice looks like than the ICC officials. So what is it that victims want? The third point, empirical research regarding the attitudes of victims and community members towards justice offers a more complex picture of the meaning of criminal trials for those living in the aftermath of mass violence. Justice carries multiple meanings. Criminal accountability is not necessarily the highest priority, and attitudes change over time. Again and again, when researchers ask about their priorities, victims and community members point to economic support as a need that consistently figures high on any list and always above retributive justice. So this draws attention to three important issues that I want to raise. One, frequently victims and members of impacted communities are poor and vulnerable, and they were so before the conflict, and the violence that they have suffered has made them only more so. Their economically vulnerable status is embedded in larger state and economic structures that contributed to the violence, which is the concern of the ICC. And yet the ICC is only able to deal with a fraction of the problems, right? The perpetrators of mass atrocities, they're not empowered to make systemic changes that might actually address the drivers of marginalization. Two, the ICC is not a human rights court and does not have a mandate to order state to adopt those structural reforms I just mentioned that would be capable of dismantling the architecture of social inequality and so resolve the root causes of victims' economic and social vulnerability and exclusion. And three, that victims have developed survival strategies that international justice must take into account. For example, researchers have studied how in Burundi, Rwanda, and Sierra Leone, complex practices of secrecy developed as strategies for living with the threat of death. These practices led communities to turn away from trials or top-down initiatives toward conciliation to make coexistence possible. In the absence of a state capable of ensuring security, to survive, communities needed to find a way to maintain and repair relationships. And this bears considering not just for the immediate concerns of witness protection practices by the International Court, but longer-term effects of trials in affected communities. And while this may sound like this has very little to do with Ukraine, I think it's important to remind ourselves of the geography there. And in the Donbass region, you have mixed communities. It's not so easy to segregate ethnic Russians from ethnic Ukrainians. We're talking about mixed communities, and questions about how will people live together after this are questions that we should be thinking about when we're designing what justice we will pursue. So what does all of this suggest for the ICC and for reparations? Victim participation at the ICC is freighted by expectations that the court is capable of transforming their lives. And there will continue to be pressure to maximize victim participation, despite concerns about its impact on judicial administration. The perceptions of victims of the court will continue to be critical to the ICC's legitimacy. The tensions between the court's ability to do justice and its inability to do social justice will persist. And reparations lies at this intersection, and the challenge will be to the extent to which reparation measures function like a human rights court to promote structural transformation that victims seek. In so doing, it's going to be critical to use tools that the ICC has, like the trust fund, which is a separate component of the court, and to use the trust fund not to just consult communities, but to build reparation programs in which victims and communities are empowered to act, to implement measures that meet their self-defined needs for repair. As scholar Rosalind Shaw notes, we need to move beyond consultation, a model where we ask you what we want, toward building collaborative relationships, the aim of which is to enable people and communities affected by violence not only to express their standpoints, but also to participate in decisions about justice and social reconstruction. In other words, the challenge is to render victims as political actors. And we need to be prepared that adopting a victim-centered approach to reparation means supporting processes and outcomes that do not reflect the trope that criminal accountability is therapeutic for victims, that acknowledgement is sought, and that victims will perceive international justice as beneficial. In other words, I think we need to open our minds to the possibility that what we define as legal justice is a small component of what victims actually desire. Thank you.
No, thank you, Laurel. And so, Professor Mohamed, we've talked about what's happened in Ukraine. We've talked about what victims would like to see happen. And now the question is, how do you actually make it happen? What are the tools that are available? And then we can talk a little bit about what's the likelihood that we'll be able to accomplish our objectives in Ukraine.
Thank you for those questions and these wonderful remarks. I'm going to spend a few minutes talking about some of the legal categories that we've been referring to, the categories of war crimes and also crimes against humanity and genocide very briefly, and then I'll turn to avenues for potential accountability for these crimes that are taking place in Ukraine. So the subject of our discussions tonight is, of course, war crimes, and we use that term war crimes often colloquially to use a wide range or to refer to a wide range of crimes taking place, and sometimes even non-criminal but still prohibited acts taking place in the context of war. But that term war crime, of course, has very specific legal meaning. And there are a number of different definitions of this term war crime. Broadly, we define war crimes to mean serious violations of the law of war that entail some criminal responsibility for individuals. So we're talking specifically about violations of the law of war that are committed during or in relation to war, that are punished through criminal law as opposed to through other means. So war crimes law has historically fallen into two main categories. First, those concerned with the conduct of hostilities, rules about the means and methods of warfare. And a second category of these rules have been about custodial abuses against protected persons, such as treatment of POWs. Over time, those two bodies of law have come together, and the instruments that punish and prohibit war crimes today do both. War crimes also have historically been divided into the categories of those crimes that take place in the context of international armed conflicts, meaning those that are happening between two states, and those that take place in non-international armed conflicts. This is a category that people traditionally think of as referring to civil wars, internal wars, but it actually can mean also wars that are something other than between two states. So the US war against Al-Qaeda is classified as a non-international armed conflict. So over time, the divisions and the rules between these two bodies of law, the prohibitions of international armed conflict and the prohibitions of non-international armed conflict, have largely come together, but some divisions remain. As we talk about what war crimes are, before I turn to how war crimes, the category is different from genocide and crimes against humanity, I want to make clear that when we talk about war crimes, we're not talking about the crime of illegally starting a war. That's the crime of aggression. And we don't typically refer to the crime of aggression as a war crime, because while aggression is a violation of international law, it is not a violation of the law of war. It's not a violation of international humanitarian law, and therefore it doesn't fall into this category of war crimes. Beyond that, what constitutes a war crime isn't affected by the legality of the war itself. So international law and the law of war observe a strict separation between the legality of the war and the legality of the conduct that takes place in war. So that means that even though a war may be entirely illegal, the soldiers prosecuting that war are still just as entitled to kill the enemy as the soldiers who are rightfully defending their state from an aggressive, illegal war. So how do war crimes look different from crimes against humanity and genocide? There have been a few references to this, so I'll be very brief. One is that war crimes are specifically about crimes taking place in war, whereas crimes against humanity can take place in either war or in peacetime. Crimes against humanity also are characterized by their systematicity. They're part of an organized effort to attack individuals, whereas war crimes can take place as an isolated matter. Genocide, meanwhile, is characterized by specific acts that are undertaken against particular protected groups, where the perpetrator of genocide has a specific intent to destroy that protected group in whole or in part. War crimes, again, may overlap with crimes against humanity or genocide, but it is its own separate category. So I want to talk a little bit about the limits of war crimes. There's, of course, the fact that war crimes have to take place in the context of war, but war crimes also only refer to violations that are perpetrated against what's known as the law in the law of war as protected persons. So who are protected persons? Protected persons are generally those who are outside of combat. So this means civilians, individuals not taking direct part in hostilities, and those soldiers who are now, or combatants who are now outside of the conflict, perhaps because they're sick or wounded, or they are prisoners. So one notable omission in the conventional conception of protected persons under the law of war is a state's own combatants. The law of war generally has nothing to say about how a state treats its own soldiers. And that is something that's of particular interest to me in my research, but also is somewhat of an alarming omission when we think about, say, the treatment of combatants by the government of Russia, and raises some very difficult questions about conscription and the context in which many Russian soldiers are fighting right now. I'll turn now to questions of accountability. So of course, since February of last year, we've seen voluminous reporting on war crimes being perpetrated by Russian soldiers. We've heard some of the horrific acts being described this evening. Though on a significantly smaller scale, there's also evidence that Ukrainian forces have committed war crimes over the course of the war. So what can be done about any of this? There are several avenues for accountability. I'll outline a few here, and I'm going to focus on criminal accountability for war crimes. The first avenue of accountability is prosecution in Ukrainian courts, and those are indeed underway. Ukraine's Prosecutor General's office has been investigating crimes as they have been happening. The Ukrainian Prosecutor General's office has been supported by partnerships with the US government and the EU. There are civilians collecting evidence. The practical challenges of investigating war crimes as they happen are clear, but the Ukrainian Prosecutor General's office is, of course, moving ahead. Ukraine has already tried some Russian soldiers and has imposed sentences on them. The international community has been urging the Ukrainians to also prosecute Ukrainian perpetrators of war crimes. Ukraine has taken more halting steps with respect to prosecuting Ukrainian perpetrators of war crimes. For example, in response to one event where there was a video of Ukrainian soldiers killing Russian combatants, Ukraine announced that they would investigate the crime of perfidy, sort of faking a surrender, suggesting that the Ukrainians had killed the Russians only after they faked a surrender. So the attention there did seem to be not on the potential war crimes being committed by the Ukrainian forces, but rather on the explanation for what was seen in that video. And this brings me back to a point that I made earlier. The fact that Russia is fighting an illegal aggressive war here, and that under international law, Ukraine has a right to prosecute this war in self-defense, it doesn't mean that the laws of war don't apply to the Ukrainian forces as well. The laws of war apply to all sides equally. Both the aggressor state and the defender state are bound to comply with the law in equal measure, and war crimes law applies equally to both sides. A second avenue for accountability is, of course, the International Criminal Court. So the jurisdiction of the International Criminal Court here is interesting because generally the court only has jurisdiction over crimes that take place on the territory of a state party to the Rome Statute or committed by nationals of a state party to the Rome Statute, or when a situation is referred to the court by the UN Security Council. We know, of course, a UN Security Council referral isn't going to happen because of the Russian veto. And Ukraine is not a party to the Rome Statute of the International Criminal Court, but as we talked about earlier, Ukraine accepted the jurisdiction of the court on an ad hoc basis. So the court can take action with respect to events from November 13 onward that constitute genocide, war crimes, or crimes against humanity. So I want to go back to this crime of aggression, the crime of illegal war. The crime of aggression, which Justice Jackson referred to as the crime of crimes, right? We might think of it as really the foundational crime. It's the one that gives rise to all of these other crimes that are taking place. The crime of aggression can't be investigated by the International Criminal Court in Ukraine because the crime of aggression has a special jurisdictional regime that's attached to it. So that means that for states that are not party to the Rome Statute, the court has jurisdiction over the crime of aggression only when that court has essentially accepted the jurisdiction of that crime. And so here there is no possibility at this point under the law of the Rome Statute for the court to investigate or prosecute the crime of aggression. Another option are national courts other than the courts of Ukraine. So universal jurisdiction refers to the jurisdiction of a state over a crime, regardless of any nexus with that crime. So generally under international law, a state's courts can exercise jurisdiction over an act, or a state can exercise jurisdiction through prescribing laws over that act based on territory where the act took place, nationality of the perpetrator, nationality of the victim, where a country's vital interests are implicated, or for a very small number of acts, universal jurisdiction, meaning that a state may open its courts to these acts regardless of any connection. The Geneva Conventions actually require states to punish what's known as grave breaches of the conventions, regardless of any connection. So they require states to exercise universal jurisdiction over these crimes. The Rome Statute requires states to incorporate the prohibitions of the Rome Statute into domestic law. And so that means that many European states now have robust laws prohibiting and punishing war crimes, crimes against humanity, and genocide. And they prohibit and punish these acts anytime a person who has committed them passes through their territory. So that means that when a perpetrator of these crimes goes on vacation or passes through or attempts to resettle, the country can apprehend that person and try them for war crimes, crimes against humanity, or genocide. And we've seen this increasingly in European countries like Sweden and Germany. For example, prosecuting individuals who are responsible for crimes in Syria. US courts may also do this. So the United States has a war crimes statute that just a few weeks ago was expanded and might allow now for prosecutions for crimes that were perpetrated in Ukraine if perpetrators of those crimes pass through the United States. So the statute was initially passed as a way for the United States to comply with its obligations under the Geneva Convention. Until a few weeks ago, however, US courts could prosecute war crimes only if the victim or the perpetrator was a US national or a member of the American Armed Forces. And so that meant that individuals who were found on US territory who had committed war crimes couldn't be prosecuted for war crimes in US courts. And federal prosecutors have never brought war crimes charges against any suspect, in part because of these strict requirements. Instead, individuals who were found on US territory who had committed war crimes typically were charged with immigration fraud for falsely stating in their documents that they had not committed certain abuses. So we have this very recent changes under the Justice for Victims of War Crimes Act. And this makes a few changes to the existing war crimes statute, such that now US courts have jurisdiction over war crimes when the crime was committed in the United States in whole or in part. This might sound somewhat irrelevant to what we're talking about, but there's some question about how broadly we might interpret what it means for a crime to be taking place in the United States. Second, if the victim or perpetrator is a US national, that part already existed, but now added to that is an alien lawfully admitted for permanent residence, and then the existing jurisdictional basis for a member of the US Armed Forces. And then third, the new grounds for jurisdiction is where a perpetrator is present in the United States, regardless of the victim or the perpetrator's nationality or where the crime was committed. So this is a huge change. Individuals who have committed war crimes should be further deterred from seeking a safe haven in the United States or merely traveling through the United States. So why was this passed? Now, the motivation for adding this present in jurisdiction really came from mounting evidence of Russian war crimes in Ukraine, and from the desire on the part of members of Congress to show support for Ukraine, and especially to do so during President Zelensky's recent visit to Washington. So this is absolutely motivated by the war and the crimes taking place in Ukraine, but the effect of this jurisdictional amendment will extend far beyond the Russian war in Ukraine. So just as European courts have tried suspects of atrocities committed in Iran, Liberia, Rwanda, Syria, among other countries, all on the basis of the perpetrator's presence in that country, the addition of this present in jurisdiction will enable the United States to do the same. So I want to just mention a couple of other potential avenues for accountability briefly. One is the International Court of Justice. So some may have heard of pending litigation before the International Court of Justice in The Hague. This is a court that specifically deals with suits between states. So this is a suit that was brought by Ukraine against Russia under the Genocide Convention. And this was triggered by the fact that Russia offered a quite specious legal justification for its initial invasion, saying it was responding to genocide taking place in the territories in Ukraine. And Ukraine responded by arguing that the court had jurisdiction under the Genocide Convention because of Russia's claim that Ukraine was perpetrating genocide. That litigation is moving forward. Will it do anything to stop either the war itself or crimes taking place in the war? Probably not, but it is part of a larger effort to get international law or international community, focused on this war and to maintain international attention on the war. A last part of the accountability mosaic that I want to mention relates back to the International Criminal Court, which I talked about at the beginning of this discussion. The United States is, of course, not a party to the International Criminal Court, but we have seen a lot of support on the part of the Biden administration for the activities of the ICC in Ukraine, and now bipartisan congressional support as well. This has included legislative change that allows the United States to heighten its support for investigations that are being done by the International Criminal Court with respect to Ukraine, and also allows it to help further with prosecutions and also support for victims and witnesses. This is a time of real change in the U.S. relationship with the ICC. And though the United States is not a member of this court, it can continue to step up these efforts to support the ICC's investigation in Ukraine. And I see this not only as a way specifically to support the activities of the court in Ukraine, but also to continue to shore up the US government's broader embrace of multilateral institutions and engagement. And I think that the war in Ukraine is a reminder of the real importance of doing that, especially after the years of disengagement and really an assault on many international institutions, including the ICC. Thank you.
So there's a lot here to unpack. I think, Laurel, you emphasized that what victims want is a combination of things. They want a record. They want acknowledgement of what happened. They want condemnation and accountability for those who perpetrated it. But most of all, they want as much of their old life back as possible through reparations and other means. Saira, what you said is that although there are a number of institutions that have been created, it's highly unlikely that that can be accomplished for many of the worst perpetrators of these crimes in the existing systems. So it may be helpful for us to kind of go through what is available for each of these different groups. So I'm just going to go through sort of the four kinds of perpetrators that are most responsible. One is just the leader of the country, Vladimir Putin, who was responsible for commencing the action and had to authorize at least some of the activities that have drawn cross criminal lines. Then you've got the senior military leaders, because it's not the people on the ground who choose to use cluster munitions or who choose to strike particular sites, but it's people higher up. And then there are the people on the ground who commit horrifying acts against individuals, either independently or sometimes because they claim to have been ordered to do so. And then finally, there's the nation of Russia. They are probably the only ones with the resources to provide adequate reparations to allow people to move forward in Ukraine. So if we're trying to understand, and so if we use that as a frame, Vladimir Putin, he can't be brought into the ICC. If he comes to the United States, he probably could be, well, could he be brought into the ICC now?
Yes.
Yes. How?
So there would have to be a prosecution. So at this point, we have an investigation that started in the ICC. There are no open arrest warrants. The court can use sealed arrest warrants. So there could be sealed arrest warrants that we just don't know about. One major challenge to prosecution of a sitting head of state is questions of immunity. Immunity for a sitting head of state, head of government, and foreign minister is going to be absolute in national courts. So sitting head of state can't be prosecuted in Ukrainian court. The International Criminal Court takes the position that those personal immunities for these top three officials don't apply before an international criminal court. And so if it's fanciful to imagine it right now, but if Putin is apprehended and there is an arrest warrant filed against Putin, there is no immunity issue before an international criminal court. It's only before a national criminal court. That's an issue that some will dispute, but the court has taken the position that a sitting head of state can be subject to prosecution in the court.
Now, Laurel, you had mentioned some forms of tribunals that existed before the International Criminal Court that were seen as less effective in the sense that they were you were trying to build a fire department while a fire was raging, and to have an International Criminal Court already established meant that you could have the infrastructure, the ability to gather evidence, prosecutors, people building cases, even as a war was going on. But at least those have successfully prosecuted people like Slobodan Milosevic. So one of the questions is, do you think there would be a need for or a value to having an ad hoc tribunal established for Ukraine?
I mean, the question in the ICC, there's a lot of criticism of the ICC, but it is kind of plug and play. It's ready to go. So I think one of the questions would be, well, what does an ad hoc tribunal get you that the ICC doesn't? Because just of the real practicalities of you generally look to ad hocs where you aren't going to be able to use the existing infrastructure, either because most generally because the ICC wouldn't have jurisdiction over the crimes, but we don't have that case here because Ukraine is a states party. So to me, it's less clear what the upside value of that would be, although I've heard some talk about that. It hasn't made a lot of sense. I think for me, the more interesting questions are, how can you build on like, what is missing from the ICC that needs to be augmented in order to to effectuate realistic and holistic measure of justice in Ukraine. And in general, what the ICC, we have to remember, we always talk about Nuremberg as though somehow international criminal justice were singly responsible for the resurrection of Germany as the leading economic juggernaut and democratic kind of beacon in Western Europe. And it was, we talk about Nuremberg, we don't talk about the Potsdam Agreement, right? Which was the peace agreement, Potsdam Agreement, which was the peace agreement that the Allies executed with Germany. And that's where you had the legal obligation and authorization to essentially rewrite Germany's constitution, demilitarize the economy, and do a lot of other things, including that laid the framework for Germany to pay reparations, war reparations, for its damages that it inflicted on civilians during the war. And those were paid to states. The state of the law has evolved since that time, and it is now widely accepted that reparations are also owed and can be paid directly to victims, right? Which your work and the Iran Claims Tribunal is a part of that development. So here you have Russian oil money, right, that you could actually use and divert, and there's talk, that I'm sure a good measure of that money is going to go to just rebuilding infrastructure in Ukraine, which has been decimated by the war. But that money could also be used for reparations to victims. And what is likely to be part of the counter argument is no. Victims have gotten their reparations by rebuilding their economy. And what victims will say is, no, that is not, reparations is a specific remedy that recognizes the damages that I, or as a member of my community, have suffered, and that economic development is not the same as reparations for the crimes that I have been subjected to. And so at administering a comprehensive victim reparation scheme, as you know, personally, is complicated and time consuming, but it can be done. It can be done. And there are not a lot, because these aren't funded, but there are examples of how that's been done. And so I think it's not losing sight of the fact that if we just talk about criminal accountability, what we're not talking about is how do you actually fund the measures that are going to penetrate to the individual and community level and make meaningful reconstruction possible.
So, Sarah, question. One of the questions people have about the International Criminal Court is whether it's really operating for purposes of being a court at the highest level for Stalin Putin, or whether it's really a way of trying to create leverage for some kind of diplomatic resolution of a conflict. And so it technically can prosecute Vladimir Putin, but it seems highly unlikely that it would. And the reason is because at the end of the day, either, unless Ukraine conquers Russia and Putin is out, it's more likely that there is some kind of treaty signed. And one of the aspects of the treaty that is essential to getting Putin's signature is that he has immunity and won't be prosecuted. And so if that's if that is kind of the end game, do we feel that the ICC is doing part of its job to accomplish what victims are seeking? Because it creates a lever, or does it kind of diminish the importance of international law and criminal law to see it only as a bargaining chip?
Yeah, it's a great set of questions. I think it's important to consider what criminal prosecutions can accomplish, as Laurel has so elegantly explained, and also what we want criminal prosecutions to accomplish. I think when this court was created, it was done so with, with very lofty goals that echoed those of the ad hoc tribunals, goals about reconciliation and closure and stopping these crimes from happening again. And it's very hard to find evidence that prosecution of crimes by the ICC is contributing to deterrence. It's hard to find evidence that it's contributing to that sense of closure for victims. What criminal prosecutions do primarily is criminally prosecute the people who are subject to the prosecutions. And so if you want to put particular people in prison, the ICC or Ukrainian courts or Swedish courts or US courts one day are a great way to do that. And that's not nothing. I do think it is meaningful to punish a person in some way. Maybe 25 years in prison is or isn't the way to do it, but I do think it's meaningful to punish a person in some way for having undertaken these crimes. But I'm not sure it's going to accomplish anything beyond that. So why are we always talking about criminal accountability in this way? One is because it's direct and it's immediate and it's fast and we know what it looks like, and it's very satisfying to know what that looks like. But I also think in the context of Ukraine, the reason that there is so much focus on the ICC and criminal accountability, and now we have a massive discussions happening around criminal accountability for aggression, and discussions in the scholarly community and the diplomatic community, and Ukrainian officials asking right from the start, let's create a tribunal to prosecute the crime of aggression because there's no other way to do it. Why is everyone so focused on this? Because of the understanding that Putin himself is a dangerous person and is destabilizing to the entire world order, and that the appeasement that's happened for a long time now isn't going to work anymore, and that we need to think about ways to get him out. And so that's how I come to your question about sort of how we use this court, right? I think, over time, I do think the conversation has changed somewhat about using the court as a bargaining chip and how we think about amnesties. And I think it's possible that, immunity from prosecution could end up being a line in a treaty negotiation. But I also think, the top leaders of Russia, they have plenty of bargaining chips. And whether we're talking about, immunity in the ICC or immunity somewhere else, or a villa in some nice country, right? Like there's a lot of power there. And so I'm not sure that it's the court itself, right, that is the problem when we think about all the power that Putin is able to exercise. I guess the last thing I'll say on this question is, the immunity questions are complicated. We've often talked about the existence of personal immunity, so the immunity that attaches to the head of state, while that person is in office, as a source of motivation for that person to stay in office. I think that's true, but I also think there's lots of reasons that a Putin or a Bashir in Sudan want to stay in office, aside from the fact that they get to exercise that immunity in a national court, though not in an international. And so again, it's not sort of the operation of these courts that's the problem here. I think it's all that power. The last thing I'll say, just on the subject of Bashir himself, is this is not meant to be sort of comforting at all with respect to the masses of crimes that are taking place. But when the president of Sudan was subject to an arrest warrant in 2008, at the time he was a sitting head of state, it was a time when I was working on Sudan. I think everybody watching that just thought, like, this is never going to happen, right? Like this is a person who's going to stay in power for the rest of his life. He knows not to travel to Germany. He's just going to keep himself safe. He's rich. He's comfortable. Nothing is ever going to change. And of course, the politics of the country changed. And now he hasn't been handed over to the ICC yet, but he's no longer president. And there's at least discussions underway for him to be handed over. He's being, tried domestically in Sudan right now. So when you sort of look at the longer perspective of the politics and the immunity questions, it changes. But that, of course, doesn't answer all the horrors of today.
No, but it is a sign of hope. And Charles Taylor was also charged and convicted by an international body. I know we're at time, but if there are any questions, I think the panelists would be happy to take one or two. Yes.
It seems like war crimes have been pretty well codified.
I'm said. Mm-hmm.
It is less so than war crimes, so it's spottier. And one tricky part about national jurisdictions and aggression is by definition a crime that's committed by leaders. So we're talking, 10, 20 people max. And typically who you want to prosecute for the crime of aggression is the head of state. Like, that's usually the person who's responsible for the crime of aggression. And national courts cannot prosecute a sitting head of state. So as long as Putin's in power, national courts have no role to play.
One of the ironies of the crime of aggression, of course, is that's an invention of a political scientist from the USSR, that it was devised in the 1930s or 1940s, and it's still rattling around today.
One last question.
It's not aggression if it's a non-international, right? Like if it's a civil war,
Right.
It's not, aggression has to be state to state.
Right.
And then finally, just from the Zoom audience, maybe this is one of the ships at sea. This question comes from someone I'll refer to as a distinguished federal jurist. My comments reflected the concept of victor's justice, and
Yes.
this relates to that. Were the fire bombings of Dresden and Tokyo war crimes, given the indiscriminate killing of citizens?
Yeah. No, I mean, that is I think the criticism of international courts has been there is inconsistent application, and that typically, unless you are a poor country and have lost, you are unlikely to feel the full weight of international criminal justice. On the other hand, if you are successful, you'll negotiate your way out and it'll simply be a bargaining chip. And if you are a powerful country, including a country that's on the UN Security Council, then you're likely to receive very different treatment. Nevertheless, for all its imperfections, it's the best system that we have ever had for international justice. It's an immature system, but I think with brilliant minds like Professor Fletcher and Professor Mohamed and the commitment of other people, it will only get better.
Well, certainly the only didn't get better since 1945 when we started to have these institutions in place.
Right.
So let's have a hand for our panel here, please. Thanks for sponsoring the program. Just wanted to also thank Audrey Barrett Alex Murray, and Lana Constantini of the staff and the court staff as well, Kwame Copeland, Sam Gerard, and Bradley Vandehay. And we'd love to invite you to our future events. So you can get the QR code outside or sign up or become members of our societies or donate to us. We greatly appreciate it and look forward to seeing you at future events. And with that, we're adjourned. Thanks very much.